Unfair way that student loan debt is treated under the Bankruptcy Code. This is a problem we should have addressed a long time ago. I actually chaired a hearing on the same subject in this same room in 2012. At that time, I was alarmed that student loan debt in America had surpassed $1 trillion. Now, less than a decade later, it has climbed to $1.7 trillion. 45 million Americans carry student loan debt, and they're not just young people. 8 million are over the age of 50. Some are now learning that their Social Security checks are being garnished to pay the debt. These loans are with you for life. If you fall on hard times, forced to file bankruptcy, your mortgage debt can be discharged. Your automobile debt can be discharged. Your vacation home loan debt can be discharged. The mortgage you co-signed with your kids so they could buy their first home can be discharged. But it is virtually impossible to get relief from student loans. Why? Because student loans are one of the very few types of debt that are exempted from discharge in bankruptcy. Concept of bankruptcy is a clean start, but not if you're dealing with child support, alimony, overdue taxes, criminal fines, and student loans. I'd like to turn to a brief video that highlights the need for this conversation.
I have paid $120,000 and I still owe $76,000.
We've put off major life decisions, put off having children.
I can't afford to retire.
With interest, there's about an extra $20,000.
The United States student debt crisis is up to $1.7 trillion.
If a university degree was supposed to give you a head start, then crippling debt looks like it's going to be the ball and chain.
Student debt in the US is now bigger than debt from credit cards and auto loans, and is second only to mortgages.
The number of Americans aged 60 and older with student loan debt quadrupled between 2005 and 2015 to nearly 3 million.
Debt is penalizing millions for going to college.
That debt is a weight that has many Americans pulled down, even more so in this pandemic.
It's the federal government that holds the vast majority of the student loan debt.
It is the most collectible kind of debt there is. It is non-dischargeable in bankruptcy.
Don't forget, bankruptcy is not a crazy thing. It happens in American life all the time. Sometimes for medical bills, and they file for bankruptcy.
In America, even a bankrupt gambler gets a second chance.
The promise of the Higher Education Act that Lyndon B. Johnson worked so hard for in 1965 has not been met.
Since I announced this hearing, people have been sending me stories. Linda Navarro, veteran of the U.S. Navy, went back to school when she was 39 years old. She's now 70. She has $145,000 in student loans. She has carried this debt for 31 years. She wrote to me, "There's no way to look forward." Renisha Bradley, a single mom with 3 kids. She's a hotel desk clerk. She has $51,000 in student debt, I should say. She's trying to get it discharged in bankruptcy. The Department of Education is fighting her all the way, saying she spent too much money on buying food for her children. Lisa from Arizona, mother of 2, filed for bankruptcy in 2008, 13 years ago, but couldn't discharge her student loans. She now owes $217,000. This is new in America. It didn't used to be this way. Before 1976, student loans were treated like other types of unsecured debt in bankruptcy. If you were facing financial ruin, you could get relief. But then Congress got the idea that student borrowers were running to bankruptcy court right after graduation. This notion was based on more anecdote than data. But Congress started passing laws to make it harder to discharge student loans. From 1978 to 1998, Congress made it so there were only 2 ways to get a student loan discharge: prove you had undue hardship or wait a period of years after the loan became due before filing bankruptcy. First, it was a 5-year waiting period. Then it became 7 years. Then in 1998, Congress rewrote the Higher Education Act, and as a budget offset, tucked in a provision getting rid of the waiting period for student loan dischargeability. Under the law now, there is no length of time, no waiting period. Now federal student loans can only be discharged if the borrower proves he or she had undue hardship. Well, that's an interesting standard. How is it applied? Proving undue hardship is nearly impossible. Starting with a 1987 case called Brunner, courts have interpreted the phrase to set an impossibly high bar for relief. To pass the Brunner test of undue hardship, you have to convince a bankruptcy judge that it's hopeless that you'll ever repay, while the Department of Education or its guarantee agents are on the other side arguing against you. In 2017, the Wall Street Journal looked around for undue hardship cases. They found four cases in the nation when a bankruptcy judge discharged student debt for undue hardship. 4. I've tried for years to push the Department of Education to stop aggressively challenging undue hardship claims by student borrowers. I'm still pushing. I use the example of a quadriplegic disabled veteran. It didn't move them a bit, but Congress can. We made a mistake in 1998. Undue hardship should not be the only path to address student loans in bankruptcy. There should be another option. We should go back to how it was before 1998, when borrowers could seek relief after a significant waiting period. That system worked. That's why today I'm introducing a bill with Senator Cornyn, and I thank him for joining me in this bipartisan effort. It's called Fresh Start Through Bankruptcy Act. We have talked about this problem of student loan and student debt long enough. It's time to fix it. Our bill would restore the ability of student loan borrowers to discharge federal student loans after a waiting period of 10 years. And it would pair this reform with accountability measures for colleges and schools that have consistently high default rates. We are sending a message to these schools. You are loaning taxpayers' money to students who count on your advice. The system is broken down. Universities have to be part of the solution. Everyone has skin in the game. You are no different. This is a big moment. I've been introducing student loan bankruptcy for a long time. This is the first time it's been bipartisan. Thank you, Senator. With this bill, we see a growing bipartisan consensus that the status quo isn't working and we need student loan bankruptcy reform. I want to thank Senator Cornyn again for joining me, and I want to thank our panel of witnesses for being here today. I'll introduce them in a moment after Senator Grassley makes opening remarks.